Hello and welcome. You're watching the Wire and Apar. I'm Sravasti, Dasgupta. While allowing podcaster Ranveer Alabadia to continue airing his show, the Supreme Court earlier this week suggested that the union government should draft a set of guidelines to monitor or regulate content on social media and OTT platforms. Now, it also noted, interestingly, that some people are making comments through news articles and stated that the freedom of speech does not is not. This freedom of speech has certain duties and it flows with these duties. Meanwhile, starting April 1st, 2026, income tax authorities will be able to access your bank accounts and social media accounts as well, according to the new income tax bill if it comes into force. So what does all this mean for freedom of speech and expression, privacy and more? To discuss all this, we are being joined by founding editor at The Wire, MK Venu, and Apar Gupta. He's an advocate and current director at the Internet Freedom Foundation. Thank you so much for joining us. First off, let's get started with the new income tax bill, which has caused a lot of concern to a lot of people, because what we are finding out from a copy of the bill and news reports that have surfaced this week is that according to Section 132 of the IT Act 1961, which is in force at the moment, income tax authorities have the power to conduct searches and seize assets and books of accounts if they have information and reason to believe that the individual has undisclosed income or documents that they are hiding for tax evasion purposes. Now, this ordinarily allowed them to break open lockers and doors, or in any case if keys were unavailable and if they had reason to suspect that this person has some undisclosed assets. Now, according to the new bill, this power now extends to a citizen's mobile phones and computer systems under what they call the virtual digital space. Now, before we get into the privacy aspect of it, how do you see this venue, particularly where the bill states that reason to believe? That could mean anything.
Yeah, it is. I mean, it's of a piece with what this government has been doing with the privacy of citizens, and wantonly, recklessly, they have been getting into seizing mobile phones, computer, laptops of not only journalists but other firms that they've been raiding from time to time, whether it's ED or IT. This has been going on, man. This is merely further giving themselves more powers to do the same. And companies like Amazon are in court, in the Supreme Court, contesting the manner in which the wholesale kind of seizure of laptops, where they are arguing that all their data, and Amazon is a large firm and has very critical data of various kinds, which affect their business. It's all there, and so are many journalists. Media organizations are in the court contesting this. I guess this is a income tax giving itself more powers. I don't know why they're doing this, because in the past income tax has publicly said that they through credit cards and through various other mechanisms, they have a full kind of view of how taxpayers spending habits, assets, and therefore incomes. GST was a mechanism to actually get a trail of revenues and target income tax. With so much that they already have, and they're linking of PAN card with Aadhaar. I mean, with all this, they still want more powers. I don't know, maybe Apar will be able to explain what is going on.
So I just want to come to you, Apar, on this, that how they're defining digital space. They're saying that it's an environment, area or realm that is constructed and experienced through computer technology and not physical, tangible world, which encompasses any digital realm that allows users to interact, communicate, perform activities using computer systems, computer networks, computer resources, communication devices, cyberspace, internet, World Wide Web and emerging technologies, using data and information in the electric form or creation on storage or exchange. So this could include emails, social media accounts, bank accounts, and a wide ranging available services, cloud services, digital payments. So what would this mean for individual privacy?
I think the first thing which we need to consider is that under the earlier Income Tax Act, the power to gain access to documents was restricted to physical documents when they did exist before the internet and digitization came into place. And what quite often used to be the case used to be that when you keep certain documents regarding your financial records, such as a Benami Khata, that is kept separate. Now, the problem which happens when you extend the same power under Section 132 and you include any kind of thing which touches upon the digital realm, or this expansive, inclusive definition, is that we don't have that separation and boundary any longer. This allows the tax department to seize your smartphone, and the problem is the lack of safeguards or proportionality. Because prior to the exercise of the power, the conditions precedent which are there are that the tax officer should have reasons to believe, and that information they need to have reasons to believe are in your possession with respect to the evasion of tax. Now, those reasons do not need to be communicated to you or even before the appellate tribunal. And the existing powers which are there, the judicial precedent on that is very concerning. There is a decision which says that because this is a tax power, there's a justifiable interest for the state and the right to privacy does not apply. And the second one is that even if there's some illegality, for instance, in the income tax officer not furnishing a satisfaction note or not taking authorization from their superiors, even that evidence, illegally gathered evidence, can still be used to prosecute you. Now, all of this has changed, in my view, after the famous Puttaswamy judgment in 2017, which reaffirmed the fundamental right to privacy. Now, when that happens, I think this legal standard needs to have safeguards. It is not it's not an absolute argument in which that income tax authority should not exercise this power. But we need to have the pragmatic understanding that a rule of law system is imperfect. The tax authorities are quite often weaponized and have been weaponized, which is why, Venu, when you were referring to that case in the Supreme Court, the first petition actually is not by Amazon. It is by journalists who have approached.
They joined that petition.
Yeah, Amazon has joined the petition. It is journalists who first went to the court and said that we need certain guidelines for the seizure of our devices because it is impacting our sources. So I think that the provision is very broad, firstly. Secondly, it does not have safeguards and it is liable to be abused, and even when it will be abused, okay, and there are very little safeguards, even then the evidence will be admissible in court.
So I want to ask you, because in just in connection to what you were talking about, the Puttaswamy judgment, so that their privacy was held as sacrosanct and a fundamental right. So how will this, you think this particular part of the new income tax bill will hold judicial scrutiny if we see it in light of the Puttaswamy judgment?
Very soon. I think so. That's because the Puttaswamy judgment, when it laid down reaffirmed the fundamental right to privacy, said that the state can in certain cases interfere with that privacy, but it needs to have certain thresholds which are first set and certain safeguards which are then there. For instance, does it meet any reason that the reasons why such an expansive seizure, for instance, if a income tax official walks into somebody's house and seizes all the devices, including the devices of their children, the tablets, etc., asks you to give all access codes, that's another provision here. Why are they doing this expansive roving inquiry if they, as Venu said, if they can't get that data from your banking details? So those kind of safeguards which are lacking right now, I think so, will come through judicial precedent. But the best policy is not for the legislature or for the union executive to challenge the law and expand its powers. In an ideal democracy, it has to be to obey the decision of the court and form a law which is consistent with it.
You know, I want to just an observation. I want Apar to also chip in. At the moment, there is, as part of this might get struck down in the higher judiciary. Do you think it can get struck down? Can the judiciary lay down rules whereby the executive arms of the government will necessarily have to seek permission from a judicial authority, specifying the grounds on which they want to search, and also specifying, narrowing down the kind of data that they are looking at, so that they are not allowed to go for a wholesale sweep, get somebody's phone, computer, and get everything about their life, invade their privacy wholesale. Is that something which is reasonable to expect from the judiciary?
Venu, I have some friends who are also litigators, and we discuss quite often how the indeterminacy in terms of outcomes has just risen. So there's a high level of unpredictability what may happen from month to month, as much as the doctrine is clear in law. So we call this vibes-based jurisprudence, and the vibes are quite often coming from the political and the social conversation at that point in being. And we may be discussing the beer biceps case a little later, which just shows this. So for instance, if that prevailing narrative at that point in time is only a certain small section of the Indian population pays the income tax and is honest, and that is repeated again and again, then to a high degree, I think so, there is a likelihood that these tax powers are upheld the way they are. If, on the contrary, there are certain clear abuses and there is public pressure which comes through which demonstrates that they are being abused, then I think there will be a likelihood that a court may see that there is actual exercise, there's abuse in the exercise of this power. So I would say that it's not really clear. As much as the doctrine under Puttaswamy is clear, lawyers for years try to get that doctrine then, crystallized to actual enforcement.
That's not happened, you're saying, right?
Yeah, the chances of that, it will take time, it will take energy, it will take years for that to come.
But I think the counter argument that a lot of people would perhaps say is that if you have nothing to hide, then why are you scared? If the state does have access to your, and that too, it won't have access immediately. It is only if you do something wrong, they have reason to believe. These are the riders that are just conversations that have been happening. But this is kind of cloaking a surveillance state and legalizing.
The state is not perfect. So many officers from the Enforcement Directorate have been arrested. For what? For demanding bribes. For also saying that I have this information in my possession and it will be used against you. For the same instance, for instance, if you open a tax inquiry and you can justify these thresholds, you can walk into the offices of the principal opposition party, most of the press outlets which are critical of the government. And I think it eats away at the democratic framework. These larger political injuries, the democratic injuries, then support the smaller injuries which people face in their day-to-day lives. You do not want a person from the tax department to take away your entire cell phone. I have nothing to hide. I live my life legally, but I don't want people to read my WhatsApp conversations.
And why should an income tax why should an income tax officer, investigating officer, get details of my health which are in my mobile, or details of my other private affairs? So that's where I feel that that judiciary needs to lay down. I hope somebody goes to the court and clearly, as Apar said, in consonance with the Puttaswamy, the spirit of Puttaswamy, the state's ability or the state's desire to get into people's private lives, assuming to do some legitimate investigation, should also be rational and should be reasonable. It can't be like a
proportional.
Yeah, it has to be proportional.
It's very interesting that you're talking about rational and reasonable of the state's interference, because this brings me to the second part of what I wanted to discuss, is that the Supreme Court's recent comments which have come up in the Ranveer Allahabadiya case, and this has again raised questions of what is rational, what is reasonable, who's deciding what. But earlier this week, the Supreme Court has said during the hearing on his case, where they allowed him to continue airing his show, and the Supreme Court has suggested that the union government should draft a proposal to regulate the broadcasting of programs that offend societal norms. The court has said that the regulations must not hinder the right to freedom of speech, but must be to ensure that reasonable restrictions on it are maintained. Now, this in effect circles back to the apprehensions regarding the beginning of the case itself, which was that the government might use this case to bring back its now shelved broadcasting bill. But how do you see this really panning out, that the Supreme Court wading into the morality debate to use in a sense, this whole argument around what is rational, what is offensive, being used to regulate content on social media. And now the Supreme Court is clearly saying that maybe directions should be issued for social content regulation.
I think the Supreme Court has, I would say, has erred in giving such a wide scope for the government to now regulate content on social media, because the broadcasting bill, as Apar himself has written on it in several newspapers, broadcasting bill is very clear. It is aimed at smaller media outfits, YouTubers, who played a big role in the last elections in shaping opinion, and they are a target of this government, and it's aimed at putting so much compliance burden on smaller people that they just get buried. I mean, that's what my view is. I mean, I'm saying it very bluntly. I don't know what Apar feels about this.
Yeah, just to add to that under Section 69A and 79(3)(b) of the existing IT Act, the government can already block content online, right?
Which it did.
Which it has.
Yeah, they did. Caravan, they did.
Yeah.
Ananda Vikatan, that cartoon.
Also this.
Yeah, exactly.
Yeah, and also videos of the stampede in the New Delhi railway station recently, that as well. So what is the additional role that these regulations could have, in your opinion, given that the government already has these powers, in a sense, to block what they don't like?
Yeah, that's a good question. Yeah. In fact, I want to ask Apar, why did they at all come up with the IT Amendment Act when they are using the previous act to take down all these YouTube content, whether it's Anand Viktan or the Caravan content, on the army, the story on the, I don't know.
So firstly, the directions which are now being issued for blocking are not only being issued by the Ministry of Electronics and IT. The IT rules which were made in 2021 expanded the scope of these blocking directions which could be issued, firstly by the Ministry of Information Broadcasting, and could then be issued to OTT streaming platforms, the entertainment service providers which you have. That was the outcome of the Tandav controversy. Yes. And the second one was towards digital news platforms such as the Wire. Yeah. Okay. Now, this additional power which has been built with one more government ministry needs to be understood from the perspective of the government's continuous effort to bolster and build a censorship apparatus as it seeks to control online narratives as tele-density and low data rates continue to spread in this country. This is also giving rise to a large amount of moral panic, given that the number of people, not only our young people, access YouTube today, and that itself has in some instances had political impacts, as the CSDS Lokniti survey shows, prior to the general elections, not only on morality, it is having impact on society by itself. And here, while those censorship powers are there, those censorship powers are post-publication in a way. Right. So also you have the criminal laws. You can file cases against people who, for instance, may post something which is obscene under the BNSS, and this has been done, all of it has been done in Samir Raina and beer biceps case. I don't like saying that word, beer biceps. I've had to be forced to say it so many times now. But here, now the government, what does it want? It wants a system of licensing and registration. Yeah. What makes a censorship
compliance, basically.
What makes a censorship apparatus more effective is for you to go and seek registration to do something which you want to do, and then seek renewals of this registration again and again. And here, the government's job becomes a little much more efficient, and it can then prescribe conditions to you, and you're perpetually under the fear, 3 saal baad, or after 3 years, will I be able to do what I do?
Like what happened with the television channels. So their license expired and they were all kept hanging for another year, 2 years. Without a license, they were operating.
Just one more thing I would like to add, purely from a legal standpoint. I think it is outside the judicial ambit in a proceeding which is seeking liberty, such as bail, okay, and the ability for a person not to get arrested, for the court to then direct the union government to come up with a law. Firstly, that is not the ambit of the case. And secondly, What happens if that law is unconstitutional and we need to go to court and challenge it? Here the government will say, well, it is you, the Supreme Court, which asked us to make this law. So I think
following the bare biceps case, right?
Exactly. But still, here's the thing. I think it is not the role of the court, and goes beyond the comments which are orally made, which also, of course, are outside the realm of judicial temper.
But also interesting what you said about the fact that now the content on social media, OTT platforms is published and then it can be reviewed. All these blocking orders, etc. that can be...
But they're secret.
Yeah. So one of the concerns that was raised in the Parliamentary Standing Committee on this issue was also this, that the problem is that the content is already out there. So it has influenced XYZ number of minds already. And therefore there is a need to control this or regulate it in some manner so that it does not do public harm. How do you see that? Because I mean, this
it's a very valid question. Apar, I'm just adding to this question. Anand Wicket and people, somebody who knows them, told me that about 60% of their content still exists in the larger space. They've taken down from their platform, but it still exists in lot many places. How does that happen?
On Vikatan, I can't comment. I'm providing legal advice on that.
Okay.
And there's an order of the Madras High Court, which was issued yesterday, which unblocked the larger platform, subject to the court determining the legality of the cartoon, the caricature in question.
Okay. Subject to
But just coming back to the center of your question, right, in a way. See, when Parliamentary Standing Committee, when it says this, I think needs to just look back a decade back, okay? The UPA government is facing a lot of protest, a lot of allegations of corruption, and there is a lot of speech which also exists online, which sometimes demonizes its leadership, sometimes is potentially illegal. There is a proposal which is floated, which is called pre-screening. Does anybody remember what is pre-screening? The imagination of the government was that prior to somebody posting something online, a human censor should check it. And this was the mechanism which was proposed. Now, if you do have a licensing system, my first question is, who all will you license? In which all categories which you will license? How many people are posting things who are not doing it in the course of ordinary trade or business, but maybe doing that as what is now called an influencer economy, a creator ecosystem. You have young people, old people doing all kinds of posts. I think this is only being devised for the purposes of selective enforcement. When you cannot enforce a law against everyone, who is it enforced against? People who I don't like or people who are weak enough to suffer that enforcement. So this is why this entire suggestion about regulation or guidelines is not about regulation and guidelines. It should be viewed purely from the prism of what will happen practically, which is censorship. And censorship of those voices which are the most critical or sometimes pose a view towards society, give a mirror towards society, which society does not want to look at.
Basically, which includes small media, YouTube media, which are run by journalists, essentially. So
the same people who have been rated by tax authorities. There'll be overlap. You can draw those two circles.
So this also brings me what the Supreme Court said in the same hearing. Very interesting comments throughout this hearing and wide-ranging effects on all kinds of people. Is that the Supreme Court said during this hearing that as we said earlier, that they allowed Allahabadiya to resume airing his show, but it also made it very clear that freedom of speech has restrictions. It noted that some briefless people were writing some articles in the name of freedom of speech and expression in the wake of the whole controversy that the comments that Allahabadiya made, and it asserted that fundamental rights all flow by a duty. Now, I just want to quote what the Supreme Court has said over here. We know that some briefless people are writing some articles in the name of freedom of speech and expression. We know how to handle them also. It also added that in this country, there's nothing like freedom, fundamental rights on a platter. The fundamental rights all flow by a duty, and unless those people want to understand their duty, then we know how to deal with those kind of elements. Now, of course, we know fundamental rights come with duties, and there are reasonable restrictions.
Fundamental rights are inherent. The Supreme Court itself, in several judgments, has said you do not need to earn your fundamental rights. That is the very basis on which we fought for independence. The Constitution was made, and I think most students, if they would attend the constitutional law classes, would know this.
But this tone...
It's only subject to reasonable restrictions, which should be supposed to be adjudicated by the court.
They are subject to reasonable restrictions, but they are inherent.
Inherent, yeah, exactly, yeah.
But I want to ask you about this tone that the Supreme Court is taking and saying that we know how to handle them, and some people, briefless people, are writing articles. Who are they talking about?
I don't know, but I think the court has always had broader shoulders, and it comes with its duty. It has the power of issuing judgment, putting people to liberty, putting people or restraining their liberty, and there are vast amount of consequences. Here, the role of any public commentator who may be writing an article or a reasoned criticism of the court is not to challenge the authority of the court, but to pause it and ask it for reflection. So it needs to be seen in good faith. But I may add that these calls for online censorship and public commentary have been there for a long period of time with different judges of the Supreme Court. As much as people may say, oh, the court is polyvocal, which means that two judges sitting together may say something and two judges may say something else, and which does happen. But the thing is, I think the court has always viewed social media, it has always viewed the internet as some form of aberration which does not comply with the law, is outside the bounds of society, and I think that's a fairly antiquated notion which they need to, overcome.
But I want to also mention that just in this year, according to a report by the Center for the Study of Organized Hate, it has noted that hate speech incidents in India in the last year has seen a staggering 74.4% increase. Now, we've not seen this kind of a very hard-handed response coming from the Supreme Court on such incidents of hate speech, but very hard remarks coming for what one can only say, as you were saying, criticism of the court's judgments or rulings. So under the garb of morality, do you see that new regulations coming in for those who are critiquing only? Like, this is just to contain criticism under the garb of morality. Do you see that taking place?
Yeah, that's what Apar said. All these rules are not aimed at going after the large masses of people who are using social media to express themselves. These will be used to selectively against people who are inconvenient to the establishment, which is very clear. And by the way, the greatest irony that I saw, I'm sorry, again I'm having to use bear biceps, that gentleman against whom all the cases were launched, FIRs, there was one channel, a leading English channel, made a passionate defense of that person in the name of freedom of expression, and it also said, one of their anchors said that this is eventually will lead to further curtailment of freedom of expression. And the same channel said nothing when one of their top anchors was kind of hauled up, sedition case was filed against him, and I'm talking about Rajdeep Sardesai, he could go to Supreme Court to get a restraining order on the police. The same channel did not, did not argue the case of their own editor with half as much passion as they argued the case of this gentleman, which I have no quarrel with. I wish they had spoken about journalists before that. Journalists being, arbitrarily being, pursued by UP police or or various other police. With sedition cases, etc.
But when the court says that news articles, names news articles, obviously not any particular news article, but in general news article. So the action seems, the target seems clear, right? That criticism and the freedom of speech and expression that we are talking about is not of the general public, but of media and outlets, whether it's YouTube or online newspapers or anything that is critiquing. So the court itself is trying to curtail the freedom of speech and expression of the people?
Yes, and I think courts in India have done that quite often. I think we view the judicial system based on a civics textbook understanding, which may sometimes be idealistic, that the court is a protector. The court is also a tyrant. Okay, and the thing is that as much as I always like to believe that the courts can give us what no other institution in India can give us. For instance, the courts are live streaming transparently their proceedings, which are not happening in state assemblies right now. It's documents, its judgments are public, and quite often you don't even get that from most government departments. And we visit a large amount of scrutiny on the court. That's because we have these expectations. But if you look at the academic literature, for instance, or some of my own empirical work which I've done on, for instance, what happens when somebody challenges and says that a movie is offending their religious sensibilities. Why are the disclaimers in our movies becoming more and more prominent, a standard feature and longer? That's because the courts are negotiating freedom of speech and saying that no, you put a disclaimer before you play the movie, as much as it may not be read by anyone, just because the courts are interfering with that form of artistic expression. Or if you read Abhinav Chandrachud's Republic of Rhetoric, he says that it's not only the government, it's the courts to a large extent, which also carry a lot of social conditioning, which in my personal view comes from a certain form of the personality of a judge, which quite often happens to be a male Hindu upper caste. So I think those are projected Brahminical values which come in sometimes, in which you want content or any kind of media to be in a form which uplifts society rather than offends. So I do think so the courts have done this quite often in decisions as well as by statements. So we have to view the court a little more realistically. And it is concerning, it should concern us, it should not make us feel that the courts have always done something which disappoints us. I think we need to expect better from the courts, because it's the Supreme Court which also gave the Sharia single judgment, which struck down 66A, and to a large extent has taken decisions over or stayed sedition, right, much more recently. So it does act in a manner which does protect us sometimes, but sometimes it does go against what I do believe are certain progressive principles of the Indian Constitution.
Yeah, I want to ask you something, Apar, here. When they struck down after the Shreya Singhal judgment, is the government really following the procedures that were laid down before you?
It took about 5 or 6 years for the government to do that. People were still arrested for years. We catalogued that.
Right. I mean, in this country, it takes 6 years for a simple court judgment to be followed in the right spirit.
Example of that is in the bulldozer demolition cases as well, right? We are seeing incidents of demolition still continuing even after the Supreme Court has halted it last year.
Yeah.
So, I mean, we'll just have to see how this really pans out. But before we wrap, very quickly, I want to, because Venu is joining us today, we want to get in a perspective on what is happening in the Indian markets, which seem to be under a continued condition of bloodbath, and that's become a cause of concern for middle classes in India, where there are already very few jobs and growth has remained, private investment has been sluggish for the past few years, and job creation is not keeping pace. So Venu, tell our viewers, why is this happening? Why is this sustained bloodbath going on for the past few weeks?
See, if truth be told, I'm being very blunt. Trump tariffs, the disruption that Trump is causing is not the main primary cause of the Indian markets going down. Indian markets started going down from October onwards, when suddenly, counter to the narrative that India's robust recovery to 7.5–8% growth is happening post-COVID, it got a jolt when suddenly October quarter showed 5.4% growth, right? And it kind of, suddenly there was it was a precipitous kind of decline, you know. After that, foreign investors started getting doubts about, they were going along with the narrative in the last 4–5 years. Something will happen with India, something will happen. After all, India is, doing all right, doing all. But that there was a big jolt to their confidence. And then, since then, for 5 months running, Indian stock markets have shown negative returns, which is unprecedented. The last time 5 months consecutive negative returns happened in 1996, right? Probably it was kind of, at that time it happened because some analysts say that stock markets read future events. The 1997 Asian financial crisis 8, it was reading some storm, larger global storm coming. So that's what has happened, and this government has not helped at all by with its overall approach to both the economy, real economy and the financial economy. There is not a single statement from anybody, Modi, Nirmala Sita, anybody. Otherwise, it's such a precipitous stock market decline, continuous decline. You have to speak to global investors. You have to sort of create some confidence. There is no confidence. Yesterday, Sajjan Jindal, who prominent industrialist, was asked by CNBC, and he is very close to Prime Minister Modi also. Why is private investment not picking up? Is it a question of capital or confidence? He said there is a lot of capital, but there is lack of confidence. Now, what more do you want? It is not me or some leftist analyst saying it. It is Sajjan Jindal who is saying it. And that is the situation. And the Trump tariffs, of course, have added to the whole problem. A lot of uncertainty and a lot of serious market players, analysts, fund managers are saying that this will take about 6-7 months to repair. And the middle class has been badly hit. By the way, Nirmala Sitharaman's budget has been more than nullified by this market decline, because such fall in markets, time taken for repair, it creates what is called negative wealth effect in economics. So what they got by way of the tax break, 1 lakh crore odd, and which the government and various analysts said that now people will come out and spend, discretionary spending will go up, travel will go up, eating out, restaurants, buying of white goods, summers are coming, everything will, a rosy picture was presented. That has got smashed, because when your stocks are down, when your savings shrink, and in this case, most people are holding shares which have gone down 30-40%, which is a classic bear market. Bear market is defined as more than 20% down, bear market. So all the mid caps and all have gone down more than 20%. So people are not going to come out, and the expectation of consumer expenditure, consumption growth leading to some better GDP growth, I think for this year is a washout. This year is a washout from that perspective, washout from Trump perspective also. You don't know, because foreign investors typically wait for all these clarity on all these things, on which tariffs will affect which country. So the investor will not invest until he's very clear about what the tariffs are going to be, reciprocal tariffs are going to be. So it's this year is, as I've been saying, fasten your seat belts and
But Venu, most of the global indices don't seem to be following this trend. So if there's uncertainty on tariffs, that should be global uncertainty.
So the global markets are doing reasonably well. Now there's a separate reason for that. The US markets are not gone down so much, but they are also, because of the Canada tariffs, Mexico tariffs, they also very shaky last 2-3 days. That's why Trump has postponed it. But China is doing very well. China is up 20% this year. Korean KOSPI is up about 10%. EU indices, FTSE is up, some 5-7-10%. European markets are up. So that's also possibly because the Indian market and the US stock markets were last 2-3 years coming out of COVID, they had a much better run than those markets. So they are now, the weight is now shifted there. So all the FIs are going, and Chinese stocks, tech stocks, after DeepSeek, people are just rushing to China. And one fund manager told me that Indians can actually buy Chinese tech stocks. Like Apar can go to a mutual fund. There is a mutual fund.
Don't take my name.
No. Or you or me, we can buy a Chinese fund, tech fund, through existing mutual funds where you give rupee. You buy units, they will invest. I'm told that window is closed now, because SEBI puts a ceiling on that. So now the middle class investor can't even use the mutual fund to invest outside. the big guys are investing there. So everything is, loaded in favor of the big guys. So,
But I think the question that everybody wants to know, which Apar was asking earlier, is that so where should the middle class invest then? Given this situation, and we have all in the past few years we've seen the growth of SIPs and mutual funds, and people have been encouraged to invest in these stock market things which have now, I mean, it's in a state of volatility.
Every cycle, bear cycle, gives a jolt to to one section of the people who have entered the market. So post-COVID, some 200 million new demat accounts probably got more than that actually got opened, and all those people who have entered at higher prices have burnt their fingers. But luckily, a lot of non-stock market investments in India happen in gold and real estate. I would presume that those guys would still be safe because gold and real estate have not gone down that much. Yeah. So
you're suggesting gold and real estate?
Yeah, I mean, a typical any common sense in kind of investment advice would be put 1/3 in fixed income, 1/3 in equity, and some in gold and other instruments, basically safe instruments, government bonds, etc. So, but then the greed always overtakes such rational consideration. Yeah.
All right, so we'll keep our eyes on all these developments. Thank you so much, Venu and Apar, for joining us, and to our viewers for watching. And I'll see you next week on another edition.